This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
I would love to present our moderator for today's presentation, Michael Cooper. Mr. Cooper joined ADR Services, Inc. to focus on his mediation practice after practicing law for 50 years. Since 1995, he has mediated hundreds of complex bankruptcy, real estate, and commercial law matters. As a bankruptcy attorney, he represented debtors, creditors, and trustees in cases involving all aspects of commercial, real estate, and fiduciary law. This has allowed him to draw on his experience and knowledge to successfully resolve myriad bankruptcy and business-related matters. He was recently appointed by the Bankruptcy Court to mediate creditor claims filed in the PG&E bankruptcy case and successfully resolve disputes involving property damage, easements, and land use, among others. Mike, I will turn it over to you to present our other presenters.
Thank you, Katie.
Oh, I'm sorry to cut you off, Mike. I forgot one more thing. Everybody, you are welcome to submit questions using the Q&A function at the bottom of your screen. The chat has been disabled for the program, but feel free to submit any questions in the Q&A and we'll answer them at the end, time allowing. Sorry about that. Michael, I turn it over to you.
Thank you. Thanks, Katie. Hello, everyone. As Katie said, my name is Michael Cooper, and I'm a mediator at ADR Services. I want to thank ADR Services for sponsoring this program, and thank you for joining us. Our hour-long program today, Navigating Bankruptcy Without Sinking the Ship, is a practical nuts and bolts introduction to bankruptcy for the state court litigator. There's nothing more unsettling and disruptive when on the eve of trial or during your trial, the defendant, company or individual, files bankruptcy. It happens. It's happened to me. When it does occur, does your litigation come to a screeching halt? Can you proceed against co-defendants who have not filed bankruptcy? What must you do to protect your client's rights? What is a discharge in bankruptcy? How does it impact your client's claim? Can your client's claim survive a bankruptcy discharge? We will answer these questions. I should say, Jane and Ori will answer these questions and cover other important topics over the next hour. If you do have questions, please submit them and we'll be happy to answer them at the end of the program. So joining me today are 2 very prominent and accomplished bankruptcy and restructuring attorneys. Jane Kim is a partner at Keller, Benvenutti and Kim LLP, and Ori Katz is a partner at Sheppard and Mullin. If you want to know more about Jane and Ori, we have summary bios for them included with the PowerPoint materials. One final comment before we get started. I would expect an uptick in bankruptcy case filings over the next few years. Recall the financial crisis of 2008. That year in California, there were 133 cases filed, 133,000 cases filed, excuse me. Just 2 years later, the cases doubled to 266,000, the highest number in the century. Because of a strong economy after 2010, bankruptcy filings dropped. In 2020, in California, there were only 41,000 cases filed. But as a result of the pandemic, interest rate bumps, the end of payment moratoriums, and the possibility of inflation, you can expect to see more bankruptcy filings over the next few years, and even a greater likelihood of an impact on state court litigation. So let's get started. Jane is going to start with a discussion of the types of bankruptcy cases that can be filed. Jane?
Thanks, Michael. So I thought it would be helpful just to, in the first instance, set the groundwork for how bankruptcy, what types of law bankruptcy draws from. Bankruptcy law is based on federal statute, namely the Bankruptcy Code, 11 USC sections 101 and following. And the rules of the court are laid out in the bankruptcy rules, the federal rules of bankruptcy procedure. There's federal case law and local rules of the court that can fill in some of those gaps. But everything that we're going to be talking about here arises out of the bankruptcy code and the bankruptcy rules. And those two bodies of law are going to be really any request that's made of the court needs to be founded in the bankruptcy code and needs to be made in accordance with the procedures laid out in the bankruptcy rules. I wanted to go quickly through what types of bankruptcy there might be. These chapter references are all chapters in the bankruptcy code. So start with Chapter 13. Chapter 13 is for individual debtors only. Chapter 7 and Chapter 11 can also be used by individuals, but corporate debtors, so corporations, LLCs, etc., can also file under Chapter 7 and Chapter 11. Talk a little bit about what the difference is, but first just to go through some of the other chapters. Chapter 9 is for municipal debtors, so cities, counties, and other municipalities. Chapter 12 is for what's called family farmers and family fishermen. And then recently, actually, just on before the pandemic, as it turned out, the Congress enacted the Small Business Reorganizations Act, which was created a subchapter 5 of Chapter 11, which streamlined the bankruptcy process for a small debtor that was under a certain debt limit, to allow them to save on, to make the process less expensive for a debtor that remained operating, and then figured out a way to help them to get out of bankruptcy sooner. In a subchapter 5, there is a trustee, but it's not the same kind of trustee that I'm going to talk about in a second. A subchapter 5 trustee is there more as as a mediator as opposed to an adversary. The debtor's management remains in place, and so the debtor continues to be able to control the property and manage and operate its business, but there's a subchapter 5 trustee there to help facilitate the process. You'll hear if you're dealing with either a chapter of, well, actually in any of these chapters, you may hear of a trustee versus, say, in Chapter 11, what's called a debtor in possession. In the Chapter 7, Chapter 13, and in certain Chapter 11 cases, there can be a trustee, and that trustee, unlike a subchapter 5 trustee, will come in, replace the debtor's management of the property and take control over the property. The key difference between a Chapter 11 and a Chapter 7 case is ordinarily that in a Chapter 11 case, the debtor continues to manage and control its property and operate its business as what's called a debtor in possession. In a Chapter 7 case, for example, the Chapter 7 trustee is appointed, and the keys are basically turned over by the debtor to the trustee, who ordinarily does not, in the case of a corporate Chapter 7, continue to operate the business. Instead, the goal is to liquidate the property and distribute to creditors. So there's a meaningful difference between what happens in a Chapter 7 case versus a Chapter 11 case. There is there are certain Chapter 11 cases where a trustee can be appointed by the court, and that's ordinarily when there is evidence of fraud or willful misconduct, and the court finds that it's appropriate to appoint the trustee to take over the property and the affairs of the debtor. One last note on involuntary filings. There can be a temptation by creditors to want to file and to force a debtor into a Chapter 7 or a Chapter 11 filing. And there is a way that the Bankruptcy Code lays out to involuntarily file, to have a creditor file, force a debtor into a Chapter 7 or Chapter 11. There's a lot of caution to be taken when deciding to take that kind of a step. First, there are requirements that need to be met in order to file an involuntary case. And if it turns out the court finds that the Chapter 7 or Chapter 11 filing, the involuntary filing, was done incorrectly or improperly, the creditors that try to put force the involuntary can be liable for damages, including punitive damages. So it really is something to be considered very carefully before taking that step.
Thank you, Jane. In my early practice, I did quite a bit of Chapter 13 and Chapter 7 work. Chapter 13, just following up on Jane's comments, Chapter 13 is a way for individual debtors to pay some of their debts. It's typically used when the debtor is behind in house payments, and it gives the opportunity to catch up on those house payments. And Chapter 7, of course, is just straight liquidation. The debtor concedes that he cannot pay his debts, he or she, or the entity cannot pay its debts. And as Jane said, it's a liquidation. So thank you, Jane. Our next topic is Ori. He's going to tell us about the very powerful tool that a debtor has. It's Bankruptcy Code Section 362, the automatic stay. Ori, please.
Yeah, thanks, Mike. You know, when Mike led this off, he said, we've all been in that situation on the eve of trial when your adversary files bankruptcy and you have that feeling of frustration or fear or anger. But Mike, you forgot to remember relief. You got to be at least a little relieved, because that means you're not going to trial the next day. So first, let's talk about what is the automatic stay. The easiest way to think about it in non-bankruptcy terms is as a free injunction that the debtor just got. And when I say free injunction, I mean no showing is needed. It's not like non-bankruptcy forms where to get an injunction, you've got to show irreparable harm or balance out the harms or have some due process at least. The debtor here just gets it by virtue of filing bankruptcy. Now you see on the slide, it says Section 362 does not apply to non-debtor defendants. What I really should have written there is does not apply automatically to non-debtor defendants. If only one entity is the debtor, the entity that filed for bankruptcy, anybody else that didn't file their own bankruptcy case does not get the benefit of the automatic stay, at least not automatically. There are cases where that injunction, the automatic stay, is extended to affiliated entities or even the principals or the guarantors of the debtor. But if that's going to happen, there will be due process and there will be some showing and a chance for you to intervene before an injunction or the automatic stay is extended. So something to keep in mind. So what about operation and scope of the stay? Well, the operation is easy. That's automatic. In terms of scope, you want to think very, very broadly. Basically, the automatic stay protects the debtor, that's the entity, whether it's an individual or a company in bankruptcy, from any action taken against not only that entity, but its property and even its interests. So you can't go about it indirectly. If you're getting at the debtor, you're going to have a problem because you're going to be barred by the automatic stay. My rule of thumb here is when in doubt, don't do it. If you're thinking of taking an act, but you're on the fence about whether you're going to be violating the stay or not, better to proceed with caution, as you'll see in a minute when we get through some of these other bullets. What are the notable exceptions? Well, some are kind of, make a lot of sense and are instinctual. There's a police power and regulatory exception to the automatic stay. This isn't going to stop a criminal proceeding or something with a regulatory agency, especially to the extent that it involves the health, safety, and welfare of other people. There's an exception for secured creditors who have started the process of perfecting their security interest and just need to finish it, and it was interrupted by the filing of the bankruptcy. That's only for certain liens, typically mechanics liens, but for those of you with construction clients who are owed money or are in the process of perfecting their mechanics liens, it's tough because under California law, you've got really tight timelines, and then all of a sudden the bankruptcy is filed. There is a way to continue perfecting. There's an exception for ministerial acts. You've done everything that needed to be done. It's sitting with a clerk somewhere, and the clerk just performs a ministerial act to get it over the finish line. But the real, I think, guiding principle here is unless you're the government, like a DA or the SEC or some regulatory agency, or unless you're a mechanics lien or you're certain you're within the exceptions, you want to proceed with extreme caution before you do something that could potentially be viewed as violating the automatic stay. So if you're enjoined and you can't do anything, what do? Well, you seek to obtain relief from stay. This is made by way of a motion, not in the court where your action may be pending, but in the bankruptcy court. It's called a motion for relief from stay. And relief from stay is granted for cause. I put that in quotes, not in the slide, but air quotes that you can't see off camera. But basically, cause is very broad. And part of it is an equitable concept. You have to remember that in bankruptcy, there's a strong policy to give the debtor, regardless of the circumstances leading up to the bankruptcy, some breathing space. And so getting relief from stay right at the outset of the case is usually a low probability of success. But as the case goes on, and if you could make a showing of cause, maybe you get it. When you're in a situation where you're not sure whether you need stay relief or not, that's when you want to file a motion for relief from stay in order to get a comfort order from the bankruptcy court. And besides, a lot of the time, when your action has been stayed, whoever your non-bankruptcy judge is going to want to see a stay relief order before they're comfortable moving any further. Then finally, what are the repercussions for violating the stay? They're pretty severe. So two things to keep in mind. First of all, and this varies from circuit to circuit, but I'm going to talk about the Ninth Circuit because I'm going to assume that's where most of you are. In the Ninth Circuit, an act taken in violation of the automatic stay is void as opposed to voidable. That means if you're representing a client and you're about to foreclose on some property, and an hour prior to the foreclosure, this debtor files bankruptcy, and you have no notice of it, and you have no clue, and you proceed with your foreclosure, and you turn around and say, hey, I didn't violate the automatic stay. I didn't even know about it. Nobody told me. It doesn't matter. That foreclosure is void as a matter of law in the Ninth Circuit. The best you might be able to do is try to get retroactive stay relief. I'm not going to get into that here. Other repercussions. So what are the real repercussions for like an intentional violation? Well, number one, there are the attorney fees of the debtor in connection with bringing the stay violation to the attention of the judge. That's number one. There are damages. And with individual debtors, you could see that as emotional distress and then other monetary damages. But then finally, for those who act intentionally and flout the automatic stay, notwithstanding that they're on notice, there are punitive damages. And we've seen some big financial institutions that were pursuing claims in violation of the automatic stay get absolutely slammed, including a $50 million punitive damage from about 5 or 6 years ago out of Sacramento. The key takeaway here is when you're on the offensive in litigation and your adversary files bankruptcy, the last thing you want to do is give them a sword. And so that's why you want to tread with caution around the automatic stay. Thanks, Mike.
Yes, thanks, Ori. I was going to mention just an individual case, the penalty that a creditor received for violating the stay. It was just a woman individual case, 2014. The Ninth Circuit it was first of all, it was a $575 payroll loan. So the debtor gave to the lender a post-dated check so that when the debtor got paid, then the creditor could negotiate the check and get paid back. Well, as it turns out, the debtor filed bankruptcy. She told the creditor she was filing bankruptcy. She filed the case. The debtor received notice of the filing, and 30 days later, notwithstanding the notice, the creditor negotiated the check. What happened? The Ninth Circuit found for a $575 check that the creditor was indebted to the creditor was indebted to the debtor for $27,000, made up of punitive damages, emotional distress damages, and attorney's fees. So echoing what Ori said, be very, very careful with the automatic stay. So next we have Jane, back with Jane, will tell us about the automatic stay and the impact on property of the estate and insurance proceeds. Can a creditor reach insurance proceeds? Jane?
Yeah, so thanks, Mike. The discussion that Ori and Mike just had on what the automatic stay covers, it leads to the next question of, well, what is property of the estate that is subject to the automatic stay? And as is relevant to a lot of the folks here and their practice, your practice, the issue of whether insurance proceeds are part of property of the estate that's therefore subject to the automatic stay that Ori just discussed is a big question that comes up, and whether you can proceed against those insurance proceeds. So the answer of whether insurance proceeds are property of the estate and therefore subject to the automatic stay is it's not a clear yes or no answer. It has to do with whether where the proceeds are going. So as a general rule, as Ori said, under Section 541. Property of the estate can't be, or parties can't enforce rights against property of the estate without getting relief from the automatic stay. And as a general rule, property of the estate cannot be used outside of the ordinary course of business without getting court approval. As it pertains to insurance, if the insurance proceeds are directly payable to third parties, so for example, if you've got a D&O insurance and the beneficiaries are the directors and officers, and all of the proceeds of those policy are payable to those officers and directors, then they would not constitute property of the estate. And in a litigation, the plaintiffs, for example, could continue to proceed against that policy. If the proceeds of an insurance policy are payable to a debtor, by contrast, so for example, to reimburse the debtor for some sort of casualty insurance, for indemnification expenses, some sort of casualty, collision, life insurance, fire is listed on that slide, or pay for some other loss, then they would constitute property of the estate. Well, for those of you who do a lot of litigation practice around involving insurance, you know that often insurance policies are not completely one or the other. And in the to the extent that an insurance policy is payable, has proceeds that are payable either to the debtor or to some third party, then that's a mixed question. It involves or potentially involves property of the estate, and really the way to proceed there is to exercise caution, as already counseled, and ask the bankruptcy court to decide whether a cause exists to allow, for example, directors and officers to be able to reach the insurance proceeds, or for litigants to be able to proceed against insurance proceeds that are where the directors and officers are beneficiaries.
Thanks, Jane. Just one follow-up to Jane's comments. The garden variety case in the state court might be an automobile liability case in which the debtor is insured, but you have to sue the debtor to get to that insurance policy. How do you do that if the debtor's filed bankruptcy? You can't proceed with the case in state court. The answer is you go to bankruptcy court and you ask for relief from stay to proceed against the insured. You're still, the name of the party, the defendant, is still the defendant, but you're proceeding against the insurer to the extent of insurance coverage. And that is typically granted. That motion for relief from stay to proceed against the insurance carrier is typically granted, or I would say 99 times out of 100. Can't think of any reason why it wouldn't be granted, because it doesn't affect property of the estate. The insurance coverage is not property of the estate in that instance. So let's continue on.
Actually, Mike, if I can just add one thing there.
Please.
Of course, if the insurance policy has some limits to it, and there are other litigants that might think that that's the pie is going to get smaller and they might not be able to reach it because someone's coming in first, then you'll set yourself up for some kind of a fight in front of the bankruptcy court and how those proceeds get used. So that would be the only instance I could think of in which a court might first consider how other claimants' rights are being impacted.
Agree. Ori, tell us about creditors' committees, the dynamics, the phenomena of a creditors' committee.
Sure. So first, these only exist in Chapter 11 cases, and we generally see few individuals filing Chapter 11, although it does happen with certain high-profile figures, but mostly these are companies filing Chapter 11. And what is a creditors' committee and how is it formed? Well, a creditors' committee is kind of like what it sounds. It's a collection of unsecured creditors, meaning they have no collateral or security to support their claim. And usually it's taken from a grouping or a list of the largest unsecured creditors. And the committee size can be anywhere from 2 creditors all the way up to 9 or 11 in really big cases. But typically we see between 3 and 5 creditors on a committee. How are they formed? Well, in every bankruptcy case, there's a watchdog called the United States Trustee. It's a component of the Department of Justice. And they will interview and solicit interest from creditors and then decide on the appointment of a committee. They have discretion to do it. The judge doesn't do it and isn't involved. Why would you ever want to sit on a creditors committee if you're owed money? There's a couple of ways in which you could benefit. So one is you can have an impact on the outcome of the case, because rather than being a single creditor advancing your personal agenda in the case, as a committee, you are required to act on behalf of all creditors. In fact, you're a fiduciary for all creditors. So you're talking about what's best for all creditors. And in doing so, you have a lot of credibility with the court. So you have an ability to impact the outcome of the case. If claimants are going to be paid 50 cents on the dollar or 75 cents on the dollar instead of 10 cents on the dollar because the committee did a good job in the case, well, you've helped yourself and your client at the same time. The other thing is you'll get a lot of information because the debtor is required to work with and share information with the committee, and the committee has a lot of investigatory powers. So it's a good way to get to the bottom of things. And then finally, and this is nice, the committee is entitled to hire its own set of lawyers to be paid out of money that the debtor has. And so that's a nice advantage too, is you don't have to pay anything. You don't have a personal lawyer because you're acting for all creditors, but it's not on your nickel. What's the downside? Well, information you get, you've got to keep confidential, and you can't use it to benefit yourself, at least expressly, if you've agreed to keep it confidential. And you have this broader duty. And so you can't sit on the committee and then direct the committee to take a position that's good for your client individually, but maybe is to the detriment of all other unsecured creditors. It is a nice way to go on the offensive in a case and maybe get a little leverage in the ear of the judge. Thanks, Mike.
Thank you, Ori. Jane, what can litigants learn from the bankruptcy docket?
Sure. So, if you're a litigant, especially a plaintiff that has a claim litigation against a party that ends up filing for bankruptcy, in a lot of ways, you may think that you're hampered, and certainly your ability to proceed against that debtor is hampered in a lot of ways, by way of the automatic stay that we've been discussing. But one of the things that a bankruptcy filing can be beneficial, or can be at least utilized by a litigant, is by getting information. There's a whole host of information that you can get through the bankruptcy docket, because of the trustees or the debtor's disclosure requirements that are dictated by the bankruptcy code and the bankruptcy rules, and the fact that everything that they want to do outside of the ordinary course needs to be disclosed to the court and get court approval, means that there's a wealth of information that's available on the bankruptcy docket. And the way that you would get to it is anyone, whether you don't have to have specially appeared in the case or not, can access it publicly through the court's PACER or ECF websites. And in the case of larger Chapter 11 cases, there's often a claims and noticing agent that's appointed, that's retained, that creates a website, so you can even get docket filings without having to pay a PACER fee for free on those websites. There can be, especially in those large cases, like just so many filings that get filed on the docket, and so sometimes it can be hard to know which ones, what pieces of information, what documents might be the ones that have good information. So let's start with Chapter 11. On the first day that a Chapter 11 case is filed, there's often what's called a first day declaration, which is usually a pretty detailed declaration by, say, the company's CEO or CFO or somebody else who's high up and has a lot of knowledge about the business, the debtor's business and operations. And we'll give a whole bunch of information about laying out a narrative of what the debtor's business was, what its history was, what its debt structure looked like, and the circumstances that led to the debtor having to file for bankruptcy, and often what kind of outcome the debtor might foresee, whether they think that they might be trying to sell the business or parts of the business, or try to restructure its debt. And that can be just be very informative to parties who are interested, in part to understand, what the future of this company is going to be like, and what to watch out for, and whether there's a likelihood, perhaps, of a payout such that, continuing a litigation could still have value. There's and along with that first day declaration, that first day declaration in part will be filed in order to provide factual support for certain what's called first day motions, which are relief that the debtor is asking for from the court at the beginning of the case. For example, to be able to continue to pay their employees. Then you'll be able to learn how many employees they might have, or what their payroll is like. Perhaps to pay special vendors. So there's just going to be a lot of information there. At the other thing a couple of other things, that's only Chapter 11, really specific to Chapter 11 cases. In both Chapter 11 and Chapter 7 cases, there's at the beginning of the case, or towards early on in the case, there'll be what's called a 341 meeting of creditors. In Chapter 11, it's conducted by the Office of the United States Trustee. In Chapter 7, it's going to be led by the Chapter 7 trustee. It'll be early on in the case, and it's basically an interview of the debtor under oath. And all creditors are permitted to attend. And you can find out information, and you might even be able to ask some questions that are of the debtor at that meeting. You'll get notice if you are listed as a creditor, which you would be if you were a litigant. Also, in these cases, the debtor is obligated to file what are called schedules and statements of financial affairs. They will be filed early in the case, often as a Chapter 7 case is filed in Chapter 11, they will generally be filed within the first 60 days of a Chapter 11 case. And it is surprising how much detail is required in those schedules and statements of financial affairs in terms of the types of payments that were made in the last 90 days to 100 to a year. And there's a requirement, obligation of the debtor to list all of its assets wherever they are, list all of its creditors, all the litigation, and so you'll be able to find, again, just a host of information that's without having to do any kind of formal discovery. In a Chapter 11, there's also an obligation for a Chapter 11 debtor to file monthly operating reports that disclose as of that date, the assets and liabilities and cash receipts and disbursements from the prior month. So you can keep track of sort of where things are with the debtor. There are other motions, as I said, each time that the debtor wants or the trustee wants to do anything outside of the ordinary course, they're going to have to file a motion, make a request. And so if you see sale motions, settlement motions, motions for relief from stay filed by someone, as Ori had mentioned, by other litigants, and you can kind of get a sense of how the court is dealing with those types of requests for relief, as well as motions relating to how the case is going to resolve, plan confirmation, as the case starts to get to, say, plan confirmation, you'll see plans and disclosure statements. So it's worthwhile to monitor the docket to see what's happening. And finally, I would say the bankruptcy cases have pretty frequent hearings, much more frequent than your typical litigation, and anyone is allowed to attend those hearings as well. You don't have to appear formally. So that's also a place where you can sometimes get information about what's happening in a case. And you can go to the bankruptcy court's website to find out, to get a sense of the calendar and when the next hearing might be.
You can also file what's known as a request for notice, but you got to be careful what you wish for. If you file that request for notice, you'll get most of the documents, if not all of the documents, filed by way of motion and other things that are supposed to be provided by the debtor to parties in interest. But in the larger cases, your desk will become overloaded with documents that you have no interest in. But if you sort of want an automatic way, if you will, to know what's going on in the case, you can file a request for notice, and you will receive most filings that occur in the case. Ori, why don't we move up? We've got to move along here. Rule 2004 exam.
Yeah, so this is another powerful tool that I view as something that should be in your arsenal for going on the offensive in bankruptcy cases. Rule 2004 essentially allows you to examine the debtor, and that's both by sitting for deposition, like a traditional examination, but also by requesting the production of documents, just as you would in a subpoena or a typical document request. So it's a very broad discovery tool. What's the scope of the examination? Well, it essentially allows you to go on a fishing expedition, just about any topic that relates to the finances of the debtor, and that's very broad there, are fair game. And so you can cast a very wide net, and there are published decisions that use the term fishing expedition, which is why I put it in quotes on the slide. There are a few things that are off limits. One of those is asking questions at a 2004 exam about the dischargeability of a debt. That's going to have to be done separately if you want to challenge the debtor's discharge through separate discovery. But overall, this is a powerful tool that and your request for a 2004 exam is something that is going to be just about routinely granted by the judge and on a short timeline. So that's what's nice about it. One important limitation to keep in mind is what's called the pending proceeding rule. There is a general rule that you cannot use Rule 2004 in the aid of pending litigation. So there are nuances to this, and just because you're in litigation doesn't mean you could never take a Rule 2004 exam. But if you're clearly going on and on, not to learn about the finances of the debtor or maybe to aid you in making a claim against the debtor, but to really bolster litigation, that's going to be shot down, and there you may have an issue. But think of this as just a broad discovery tool that you can employ very quickly against a debtor. This is part of the price of a debtor being in bankruptcy. They get all sorts of benefits like the stay. This is one of the things where they have to pay the price for the benefits.
Thank you, Ari. Jane, tell us about creditor claims.
Sure, this is an important part of an important thing to know about what to do in a bankruptcy. What's a proof of claim? Proof of claim is a simple form that it's like a 3-page form. Mike, I think that we're providing that form to, or a sample of it to attendees. You'll see it's short and simple, and all it requires is a simple, concise statement about your claim. It is really important to file a proof of claim regardless of whether you have a litigation that's pending, that was pending as of the filing of the bankruptcy case. While there are certain things to be aware of, the reason that you would almost certainly want to file a proof of claim is that if you don't, you can be barred from being able to get recovery on your claim, even if you were your litigation claim were ultimately meritorious. So what are the concerns about filing a proof of claim? Well, you're submitting to the jurisdiction of the bankruptcy court, which can be tough for a litigant that went through the trouble of filing a litigation, and it's their forum of choice to have to decide to do. You can waive rights such as the right to jury trial, which isn't something that can be held by a bankruptcy court. That said, a well-crafted proof of claim can put in reservations that will allow you to continue to have those types of rights. So those, in and of itself, those concerns are not a reason to decline to file a proof of claim. And when do you file a proof of claim? Well, in most cases, there is a bar date, which is the deadline by which proofs of claim need to be filed. In smaller cases, the court may just automatically designate a bar date, and you will find out about it very early on in the case. In certain larger, more complex cases, particularly in Chapter 11, the debtor will set a bar date that might happen sometime after the schedules and statements of financial affairs that I talked about a little while ago get filed. And as a general matter, if you don't file a proof of claim in the case by the bar date and your claim was not listed on the debtor's schedules as non-contingent, unliquidated, an undisputed claim, then you may miss out on your ability to, and you may be barred from getting a distribution on your claim unless you can show some sort of excusable neglect to convince the bankruptcy court that you should be permitted to file a late claim, for, notwithstanding the fact that you missed the bar date.
Thank you, Jane. A couple of comments. In a Chapter 7 case, many times, most often, the debtor might not have assets, so that the notice that you receive, the notice of the filing, will say, do not file claims at this time. We'll let you know if there's going to be assets. My suggestion is to file a proof of claim anyway. You can miss the new notice that says, now it's time to file. We found some assets, and now it's time to file a proof of claim. If in doubt, especially in a Chapter 7 case, if in doubt, always file a proof of claim. And the website, the Northern District Bankruptcy Court website, you can file a proof of claim electronically. On the quick links, when you open the website, is a link to the electronic filing, and up pops the claim form. You fill it in and you submit it, and there it is. So you don't need to get a piece of paper and then file it with the court. So let's move on. Let's see, Ori. I think it's Ori. Yeah.
Right. So removal and remand. So the debtor has in a bankruptcy a very broad power to remove actions to bankruptcy court, so they'll be litigated there. It's very broad. It's essentially of right. If they want to remove the action, they just file a notice of removal, and essentially if they follow the procedure, it's done. So the initial step is all in the debtor's control. The timing for removal is best practices is 90 days from the date of the bankruptcy filing for anything that was pending pre-bankruptcy. There are situations in which it could be done later, but 90 days is best practices. And so if there's going to be a removal, typically you'd see it in the first 90 days. Oftentimes what's been removed doesn't belong in bankruptcy court. There was gamesmanship, and there's some reason for it to be somewhere else so that you can finish up the litigation if you decide it's worth the money. And so what factors go into a motion to remand? Because once it's removed, you can remand. Essentially, the cases talk about any equitable grounds. And what does that mean? Kind of the things you would think it would mean. Things like the convenience of the parties, comity between the courts, how much time the non-bankruptcy forum has already invested, the nature of the questions that are going to be liquidated. What kind of questions of law need to be answered? More bankruptcy type questions? Probably not. State court questions? Probably. And so those are the factors would be considered in a remand. Just remember, you may be better off just filing a proof of claim. It's only if you really have to litigate it and really if the forum matters that you would consider remand. And then, of course, even if you remand, remember, you're still going to need relief from stay to continue. You can't just get remand and plow ahead. And we already talked about stay relief. So that's all I've got on that one, Michael.
Okay, thanks, Ori. Jane, how does a bankruptcy case conclude? When do creditors get paid?
Yep, that's one thing that everyone wants to know, right? So let's start with the Chapter 11 context. In Chapter 11, there's a process that's known as plan confirmation. What is the plan? The plan is a document that shows how creditors are going to, well, first of all, how creditors are classified, and then how creditors and other interest holders are going to end up getting paid, if at all, through the bankruptcy. And all creditors are entitled to vote on the plan. If you're a class of claims that's what's called unimpaired, which means that essentially that your rights are not being impacted by the the plan, then you're deemed to have voted to accept the plan, and so you won't actually get to vote, formally vote. And if your class of claims or interests are going to get 0, then you're deemed to have rejected the plan, and so you also won't get a ballot to vote. But otherwise, you will get a ballot if you're a creditor, and a class of claims has accepted the plan if 2/3 in amount and half of the number of claims that has voted in favor of the plan. What if you have a litigation claim and you don't actually have a claim amount, right? That's set. Well, you may end up getting your claim estimated for purposes of voting, and that's something that the bankruptcy court will do, or the debtor might propose an estimation, and then the bankruptcy court can approve that estimation. And what happens? What's the effect of confirmation? Well, there's a discharge of debts. And that's actually in a liquidating Chapter 11 plan. There is no discharge, and for technical reasons that may not matter, and I won't get into that right now. Discharge of debts can also occur outside of the Chapter 11 scenario. And in a Chapter 13 or Chapter 7 case, the Bankruptcy Code also provides for discharge. And when you're talking about individual debtors, that discharge has certain exceptions. Those exceptions are delineated in Section 523 of the Bankruptcy Code, and they include fraud claims, willful or malicious injury claims, tax claims, governmental penalties, student debt, and spousal or family support obligations. There's a difference among these, which can trip you up, or has potential to trip you up, so I'll just mention it quickly. For fraud claims and willful malicious injury claims, even though the bankruptcy court excludes them from discharge, a creditor who has those types of claims has to bring a complaint in front of the bankruptcy court in order to have the court determine that those types of claims are not dischargeable. That's not the case for domestic support obligations and some of these other types of claims that are excluded from discharge, where they're automatically non-dischargeable and nothing has to be done. But if you have, say, a fraud claim, that your litigation claim, you can't just rest on the fact that, Section 523 says that that's not dischargeable and then not do anything. There's a time limit, a pretty short time frame by which you have to go and ask the court to make a determination that that's not a dischargeable claim.
Thanks, Jane. Ori, how about some tips?
Sure, this is my specialty. So number one, expect the bankruptcy judge to be very prepared. I have limited experience in non-bankruptcy forums in state court, but in general, I find the state court docket to be more crowded, the judges to have a little bit less time, and a slightly higher likelihood that there'll be this feeling of your matter of the court is overwhelmed, and there's a lot going on. That's not the case in bankruptcy. The caseload is much lower. The judges have sufficient resources. They've got clerks, they've got interns. You should expect to take the bench and ready to answer tough questions. Expect everything's been read and the judge is totally ready to go. Don't go in there counting on a continuance. That's number one. Number two, keep in mind the judge has significant discretion. A bankruptcy court, unlike most other courts, is a court of equity. And so you have to keep in mind the limited resources that comprise the bankruptcy estate, and the fact that the judge is taking into account factors that aren't always within the four corners of what matters to you. If you're seeking something and you're right on the law, but it just sounds like a terrible result, think about whether there's some way to approach it slightly differently. The judge is going to be keeping equity in the back of his or her mind as he or she rules. Next up. Be ready to move quickly. So I do have one pending state court matter. I was arguing a motion the other day, but before me on the calendar were people getting ready to be set for trial. And they were looking at dates at like 2024. for trial. Things drag on for a long time. And sometimes that could be to your benefit. Other times it could be to your detriment. But in bankruptcy, that's highly unlikely to happen for all the reasons I mentioned. This judge is going to set you, you're going to have a discovery cutoff that you'll probably need to abide by unless there's a really good reason to punt it. And then you're going to need to be ready to go to trial. So everything that should happen in a theoretical world where there's no delays and unlimited resources, not that the bankruptcy judges have unlimited resources, but things tend to go to trial on time. You need to be ready for that, and in general, to move quickly. So this point kind of ties into the equitable nature of bankruptcy and also the melting ice cube limited resources aspect of bankruptcy. At the core of almost all bankruptcy cases, whether it's individuals or entities, there's a recognition that there's only so much money to go around. Many times there are many mouths at the trough or hands out trying to get to those limited resources. And so we're often fighting over partial dollars, 10-cent dollars. But what's always true is that we are spending 100-cent dollars to fight over those 10-cent or 5-cent dollars. That dynamic yields lots and lots of deals that couldn't be done pre-bankruptcy because you had none of the transparency about the debtor's assets or what really happened, and you weren't getting discovery. Once you shed light on the situation and you understand what's really available to pay you, think about whether there's a deal that can be cut that avoids you spending lots and lots of 100-cent dollars to get there. Cut your deal and be ready to move on. And then finally, a lot of questions you have that the typical non-bankruptcy attorney have been raised thousands of times before. And in general, and this is pretty universal throughout California, the bankruptcy court websites are excellent resources. They have incredible FAQ sections. Your question may be on there. If you're having trouble with PACER or e-filing, they've got 800 numbers there as a resource to you for how to file electronically, because it's a purely electronic system. And while nobody at the clerk's office is going to give you advice, each of the judges is going to have legal advice. Each of the judges is going to have a contact for their chambers clerk. You can actually get a person and a voice when you call. And so for questions about like the judge's calendar or scheduling, or when is that order going to be entered, as long as you're not being too much of a pest, you can actually pick up the phone and call somebody. And the phone number you need to dial isn't hidden somewhere. It's right on the website. So those are my top 5 tips for navigating bankruptcy.
I would only have one more, but it sort of piggybacks on what Ori has told you. Credibility is incredibly important in front of a bankruptcy judge. They're judges that have that discretion, and they are courts of equity. What you don't want to do is get cross with the judge if he doesn't trust you or believe in you or questions what you say, because your credibility is very important and could make a difference in how the judge decides. So we're at the end of our hour. There was a lot more material we can cover, and by way, what reason I'm saying that is that if you think of a topic we've talked about that should be expanded or other bankruptcy topics, feel free to contact me, and we'll see if we can do another seminar at a later point in time and spend more time with a particular topic.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.